Hi, Warren.
Hi.
Hi, James. Good
Hi,
afternoon.
how you
Can't complain. Good.
doing?
Yes, yeah, we are again.
There we are again. Third time lucky.
Good.
We've been lucky all
You
the
feel we've
time.
been lucky with all three, yeah, so that's all good.
Good, good. Are we just us today?
Yeah.
Yeah. Can you see me all right? It's still dark outside, so the light's not coming through the window. And I haven't set up my lights yet. We've moved to a new place, you know.
It's good enough, Christo.
Right, okay.
I can see you
Yeah.
clearly. Good, all right. So I think of the three topics we've discussed so far, this is by far the most interesting, I believe, and possibly the most complicated. So let's just see where we go today. But in a nutshell, what I understand from the brief sent and what that I've reviewed, the village body corporate recovers the majority of expenses on a PQ basis, save for being water, sewerage, accounting fees, auditors' remuneration, and meeting expenses. Is that accurate? Okay.
Yeah.
And those expenses that I've just mentioned are recovered on various percentage bases, but it's not in accordance with the PQ. The position around these expenses seems to have changed throughout the years. For instance, the water and sewerage, there was a change in 2012, 2013, and the auditors and accounting fees seem to have also changed several years ago.
Can I just amend that statement? I think the auditors, that has been ongoing. What changed with the auditors was that they didn't do they didn't do a residential retail. They did that in the beginning for probably 15 years or 14 years, where they had residential, retail and combined. And then they changed to only a combined.
Okay. And when did that change come about, more or less?
I don't know if it was 6 years ago or 7. It was around about 7 years ago. So.
Okay, and before that, then what you're saying is each component had effectively their own financials that were separately or independently audited, and then a combined set.
And then they were combined. And then we decided it's not necessary. The separation should be done at the managing agent level, and then we can always see them in the management accounts, but in the financials we just have combined.
Okay, perfect. All right, and then the last expense is the meeting expenses. I'm assuming that's venue booking and sending out the notices and that type of thing. Is that what you refer to as meeting expenses, or is this trustee meeting expenses?
Yeah, and well, I suppose is the entertainment? No, whatever it costs to have the meeting, probably all the meetings too, I suppose. I don't know. I'm not sure. I'm not quite sure, because that seemed to come in at some stage. That wasn't right from the beginning.
Okay.
I don't know how that came about. I can't remember. There's no history in my mind as to when I saw that.
Okay. And then at the AGM in June last year, Christo, per your comments here, it seems as though you've raised this issue much earlier in 2013, but at the AGM last year, it was decided that the trustees will seek legal guidance on this issue and decide what the correct way to deal with these expenses will be. And then there's comments from John Anderson, I'm assuming, who's a previous residential trustee.
He was a previous residential trustee for probably maybe 10 years or so.
Okay.
He resigned last year.
And Adrian, just remind me, which came to you?
I'm a current trustee and the current chairperson of the body corporate. So I had been a trustee some years ago, but I think what's happened with this, sorry, just to fill you in with this, this matter has been in existence for a long time. Previous trustees had done, this is my view of it, and I've had meetings with John Anderson in this regard, have had meetings, they performed measurements, whether those measurements are valid or not, or whatever the case might be. There were measurements taken where a more accurate assessment of the actual usage of water was determined. And it was determined at that time, through whatever mechanism they used, that the usage of water was heavily swayed towards the commercial side. So they, at that point in time, made a decision. I don't know if it was done by special resolution, Krista, but anyway, let me finish what I'm.
Yeah.
But then basically what's happened is that obviously Krista's been a trustee, I think, from inception. I think without miss. And on the residential side, obviously there's a more frequent change of trustees, and especially I think the chairperson of it. So I think on many years in a row, this matter has been bridged and it hasn't really been discussed and finalized. And obviously there's a dispute. The dispute becomes less and less important because the actual costs, particularly of water, I mean, I think we can deal with the accounting fees and the meeting fees and all those kinds of things in a separate thing. The actual costs have decreased because we now have our own water well and stuff like that. I understand from the residential point of view, if you take those water expenses and you split them amongst all the owners, it's a very small amount. When you're looking at the commercial element and the true reflection of the true measurement shows that it's heavily swayed in their favor, or not in their favor, but it's in terms of usage. Suddenly it becomes quite a major expense for the commercial component. But because some form of analysis was done some years ago that showed over a short period of time, and I'm not 100% sure whether it was valid or not, that usage was heavily swayed towards commercial, it's not prudent of the trustees to simply say, well, we're going to go to PQ because the facts that have been presented to the current trustees show that the water usage is heavily swayed towards commercial. So so instead of this now being raised again next year and again next year by Krista, which I completely understand because it's it's a big expense, I thought the best way to deal with this was to get some form of an opinion. I understand the Sectional Titles Act, and it does say that it needs to be measured. Whether it needs to be measured by individual meters for every single section or whatever the case might be, I don't know whether that is true or false. That's what Christo assumes. But I think that's what you assume, Christo. But that's what we need clarity on, in my opinion.
Okay. Christo, do you want to add anything else there?
Yes, yeah. For me, it's not an assumption. My interpretation of the act, and I can't refer to the points, but over the years, I've kept on asking advice from other legal people, not getting official, but people that I know in the legal profession, and they said, well, every apartment has to be metered. You fairly be able to distribute the costs individually. You can't just one or two just because their meter is slammed on them and then say that they must pay a different amount, and all the others that are not on meters, they don't get measured. You can't do it one way for a few and then do a mathematical assumption proportionately that they are paying more and not know that within the section that you aren't metering, there are the individuals that are paying a lot more too, but they're in the bulk group, and so you're not fairly distributing your methodology.
But correct me if I'm wrong here. Correct me if I'm wrong here. The methodology at the time, and this is, I suppose, is what it's all about. The methodology at the time was not about measuring specific sections. It was measuring the split between commercial and residential.
I just want to talk to the methodology in general, because it doesn't matter that you've just brought up a good point, is that this is not about residential and retail. They've always done this residential story. It shouldn't be like that. When you're applying expenses, it's got to do with PQ, is my view, unless
well, it is, sorry to interfere, Krista, it is done that with certain expenses.
Yes,
So
because
it is done like that with certain expenses that are incurred exclusively for residential, like swimming pool, etc., etc. I'm just wondering. So I mean, if this,
Adrian, you're coming into my. I was talking and you just interjecting.
My apologies.
I just want to complete. I just want to complete what I was saying.
Yeah.
The residential and retail, when it comes to the expenses that are not registered in the rules or anywhere, my understanding is that it must be PQ, and unless it's mentioned in the rules or in the sectional title act, that sort of thing should be done in any other way, or unless it's very clearly measurable that one section is doing something and the others are, we really measure it accurately in a fair way. Everything has to be done PQ. That's my understanding, unless it's in the rules and regulations. So that's as far as I have to say about it.
All right. Adrian, is it, sorry, just I don't want to take up too much time.
Yeah. No, and I think Krista is 100% right in terms of costs that can't be determined in some form of way. It's the determination of those costs that Krista is saying the measurement that was done back then is not fair. And we're not legal experts. We don't know whether the measurement done back then was fair. I think what gets to the residential people, though, is the fact that there hasn't been an argument that commercial uses more water than PQ. Therefore, it makes sense that the PQ split is unfair. And that is really what, I mean, I'm not one way or the other. To me, it doesn't make any difference. I'm just trying to represent all the trustees in terms of saying what's the legal standpoint on this. That's what we're wanting to find out.
Adrian, can I ask you to rephrase that statement? Because I struggled to understand exactly what you meant by the usage of via PQ. Just rephrase that.
So that there was a test done at a point in time which showed that commercial used more water than residential.
Okay.
It didn't use water in PQ.
So let me try and explain the way that I'm here. What I'm hearing is on a rough basis, it's about an 85-15 split. Okay.
Yeah.
I'm saying that if on 100%, the usage wasn't 15% of the usage wasn't retail. It was, I'm just rough figure, 40%. But
it was more like 60%. Yeah.
Okay. So 60%, and it doesn't correspond to their PQ. Okay.
Correct.
Yeah, what you're saying. So in effect, the residential owners feel as if they're subsidizing the water.
They're subsidizing commercial. Yeah. Things have changed. Sorry, just to point out various things. So things have changed since then. There was actually a gym in the building, which maybe used a little bit more water. Most of the commercial, not most of, but a lot of the commercial space is operated by restaurants, which one would understand that they would use more. The assessment may also have been done at a time when it was off-peak season, when a lot of the residential units are empty. So admittedly, during peak season, the usage may be different. All I'm trying to say is, what is the legal? I don't believe that. I think after this discussion, we need to go back to the trustees and say, listen, this is the way, this is what Oren has advised us. But I think it wouldn't be prudent for us to just make a decision to go, well, Krista feels that the measurement done back then wasn't fair. Sorry, Krista, and therefore we should go with it. We needed to have an opinion.
Just to finalize the part where the measurement was unfair, the other component is there are different tenants have changed hands. So the measurement over, I think it was done over a 3-month period where they measured from 5% of the units, 5% of the whole complex, which happened to be retail. It wasn't the 15% that were measured, because we can't measure what's in the other retail. It's part of the residential block. It's in the same block, and they don't have meters. They don't have water meters, and they don't have water access in those units. So there's also another exponentially unfair situation when they did those calculations that they now must apply every month to be equitable when the usage changes. So that therein lies also the inequality in my mind.
Okay. All right. If you're happy that I feel enough of a brief, and I want to jump into actually giving you some advice. So I'm going to start off by explaining the default position under the Sectional Title Schemes Management Act regarding the recovery of expenses. And then I want to specifically deal with the conduct rules applicable to your body corporate and what effect they have on that default position. Okay, so in terms of Section 3, one of the functions of the body corporate is to establish and maintain an administrative fund and a reserve fund. Now, the admin fund is there for purposes of defraying the costs of repairs, maintenance, utilities, insurance, all the costs relating to a body corporate, common costs. And it doesn't require an accurate measurement of those costs. What it does require is it requires it to be reasonably sufficient to defray those costs. Okay, now this is specifically relating to utilities, so water and electricity. So the body corporate needs to budget for the expected usage for the 12-month period and recover enough levies to defray those costs. And those levies are recovered on a PQ basis. This is the default position. Regardless of the actual usage of the respective owners, they pay their contribution on a PQ basis. Now, the Act does make provision for a slight deviation from this position, and it allows the body corporate either to install water meters to measure water and electricity meters to measure the actual usage, and then to recover the usage on the basis of those meters read, or for the body corporate to install prepaid meters. Now, the caveat is that it cannot be a hybrid approach where some owners are required to install meters and to pay based on a meter usage basis, and others to pay on PQ. It has to be an either-or approach. So I'm picking up that there may be some sections in your body corporate that have meters, possibly, or this exercise was done by measuring only certain sections by way of a meter. But the point that needs to be made is, in the absence of meters, in the absence of every section having a meter, whether it be a normal meter or prepaid meter, you need to recover on a PQ basis, not only water expenses, but insurance and what have you. Okay, so the default position is very straightforward, very easy to understand, and there's no room for any dispute there. It's PQ, finished and clear. Now, where the dispute and the issues creep in is when a scheme has rules by which a determination has been made, either by the developer or by the members of the body corporate, in terms of what used to be Section 37(1) of the Sectional Titles Act, and now is Section 11(2) of the Sectional Title Schemes Management Act, and a determination which modifies the effect of PQ when calculating contributions to to the body corporate's expenses. Now, and what this means in a nutshell is the developer or the members can decide we don't like the PQ approach and we want to actually split the costs on a different basis, which is applicable and appropriate to your scheme. Now, I see that, and I'm not sure okay, I hope that you are aware of the rules. I'm not sure whether they've been applied, but I see that you do have a determination that has been made in your conduct rules that you sent to me. If you read conduct rule 26.3 to conduct rule 26.10, a determination has been made whereby the proportions in which owners make contributions and their liability to make those contributions has been modified. And then it sets out how that modification works. Now, it's a very, no offense to whoever drafted this back in 1990, whenever.
1999.
No offense to whoever drafted it, but it's really a poorly drafted determination, and it doesn't do you any favors. It's open to disputes, and it's going to cause quite a lot of disputes if we strip it out to its plain form. But in a nutshell, the intention, from what my reading of this determination, the intention behind this is that contributions in respect of the residential and commercial portions of the scheme shall be collected separately and shall be dealt with separately, to the effect that separate expense accounts must be created for each portion in terms of this rule. Okay, so that's the first issue, separate expense accounts. The second intention is that all expenses incurred on behalf of a residential unit or the residential component shall form part of the expense account of the residential component, and vice versa for the retail. And then it makes reference to an attached plan called P1, which indicates which part of the scheme is residential and which is commercial components. But this plan isn't attached. I haven't seen the plan. I don't know if you have access to that plan, but without that plan, this might become quite a difficult exercise to get to the bottom of. Okay, then it goes a bit further, and it specifically, the one expense that's specifically attributable to the residential portion is the operation and use of the lifts. So that cost is only for the residential owners to pay for, except for the electricity supplied to that lift. And then this is a catch-all clause which says expenses of or incidental to a facility, amenity, or service provided either for the commercial or the retail portion shall be borne by that relevant portion. Now we can unpack what that means in a second. And then it says where any facility, amenity, or service is shared by the commercial and residential portions, then the expense thereof shall be apportioned between the two portions in a manner that the trustees deem equitable. Okay. And I hope you're starting to see how this is just going to lead to disputes. It's very, I think, very wishy-washy and vague. And then here is the final little category is expenses other than those referred to above in this determination shall be borne by the residential and commercial portions respectively in proportion to their participation quotas, provided that separate water and or electricity meters may be installed if they are installed at the same time for both the residential and commercial portions, and in such event the respective portions shall pay the costs of installation of such meters in equal shares and pay the charges meted out on such meters. Okay, so my first question to you is, are you aware of this rule, or at least this determination?
No, I wasn't. No.
I was aware of those clauses, but not in terms of them being in any way superseding the Sectional Title Act.
Okay.
But
so then my next question answers itself then, is that these clauses have not been applied in practice.
Yeah, they haven't been.
Well, maybe they have been in terms of them determining the water and then making a majority decision. You know, the trustees made a majority decision about applying the new rates that they put in. You know, so
because this
maybe they did without knowing that they could do that from the rules. I don't know.
because the comments from John Anderson, his 12th of October 2021 comments that he makes regarding Tertius Marie and the engagement that they had with him, starts to make a bit more sense if one reads this rule, because the advice that he got from Tertius, who just, by the way, has passed away about 2 years ago, but the advice that they received from Tertius is that a special rules resolution was not needed, and that the trustees could pass a motion implementing these changes. And if one reads the determination, it makes sense, because the rules specifically give the trustees certain powers where there is uncertainty to determine what's equitable to share, what costs to share and how to share them. When I first read John Anderson's, because I first read the comments and then I read the rules, when I first read John Anderson's comments about Tertius's advice, I thought, no, that's not right. If you do want to deviate from PQ or modify the effect of PQ, a special resolution is definitely required in terms of section 11.2 in order to make this determination. And then you insert that determination into your rules. But that in fact has already been done, which is why Tertius said a special resolution isn't required. Now it's about applying, first understanding and then applying that determination in practice.
My understanding of the unfairness of decision making, that the trustees have the power, and this is where I feel it would probably go to court if it was accepted to be fair, is that the majority of trustees, the residential, are always in the majority. So they can't enforce in the minority just because they are a majority and there are separate components. There's a retail component and a residential component who have their own trustees, according to the first page of those rules. So there's some fairness that needs to be recognized, that the majority can't overrule the minority just because they have that power in a clause. The application of that clause must have meaning behind it.
So this, I think, is a good point for me to quickly deviate from Conduct Rule 26 and actually go to the preamble of your conduct rules, because in terms of the preamble, specifically P4, it specifies that no fewer than 2 trustees shall be elected to be responsible for the performance of the duties as they relate to the residential component, and no fewer than 2 trustees shall be elected in respect of the retail component, and that these respective trustees shall, to the exclusion of each other, make decisions in regard to their respective component. Okay, so that, I don't know if that's applied in practice or not.
Yeah, yes, that's applied in practice.
So that's applied.
Yeah, to a relative degree, yes.
Yeah.
Okay, and then it says further, solely in overlapping areas, as described below in P5.7 to 5.13, will the trustees, will the 2 components become involved in joint management processes? So it specifically states which areas will require joint management processes, and this is P5.7 to 5.13. 5.7 deals with the management and use of basement parking area. 5.8 is the protection of the interests of members in regard to access, privacy, and security. 9 is noise control. 10 is vagrant and crime control. 11 litter. 12 maintenance of access ways, and 13 provision of public liability cover. So it doesn't deal with joint expenses. So how do you determine joint expenses? And this is where the disputes are now going to start creeping in.
Is that not covered by the common area? You mentioned the area in those areas which are common.
And so what the common area was only the only area here is maintenance of access ways. I don't know if that's what you're referring to, or
Surely water is common. At the moment, it's a single pipe that gets distributed internally and to all the different sections. That's a common use.
Yeah, but your rules are quite specific in the areas that we only it specifies areas from P5.7 to 5.13 where joint management processes will be required. It doesn't have a catch-all phrase where or any other areas common to the body corporate. So it's really only drilled into those examples that I've read out, which don't mention common usage, or at least common expenses. But I think that the rules in general, as a passing comment, are quite problematic. They've been drafted in such a way that you can see, I believe the developer drafted it on my reading of them. It sounds like a set of objectives or a list of objectives that they wish to reach at some stage, as opposed to a set of conduct rules. It's more like a wish list, the way that it's been drafted. So that's the first problem with them. And the second is there's an attachment missing, which is very important. And third, it's not clear on this document that I'm looking at whether these were in fact filed at the deeds office. I don't know if you have.
Yes, no, the copy that you've got excludes that which was come from the deeds office. In other words, there's the conduct rules are included in a whole set of.
Okay, so you have confirmation at least that these were filed, because
yes, yeah.
Some of the rules actually read like a marketing material.
You know, at the time, the Janus de Villiers, which is now Baxman's, they did the rules, and I wasn't part of putting it together. I can't remember the who from the developing team spoke with them and dealt with them. You know, I was not part of that aspect, so I don't know how that came together. But it's clear that it needed the rules need to be amended, and we have been in the process for the last, I think, 6 years. The changes in 2016. We've got the conduct rules completed, just a few things, and then we've got to do the management rules. So we are in the middle of that process.
Okay, so then it might be the opportune time to really get some momentum in that process, because we can either continue under this current dispensation and feel our way through the dark to try and figure out what is required, or we can now decide, okay, by February next year, we want a new set of management and conduct rules put together to clearly set out what the parameters are regarding this determination, and also what the trustees' rights are in respect of voting on certain issues. So you've got to, I believe, use that energy in a positive manner and try and just reach a point that you would be able to function without disputes, as opposed to trying to really butt heads on what you've been left to use by the developer.
Yeah. No, I would agree with that. I think that is, I think that's, Oren and Chris, I think that's the purpose of this meeting. We call it a dispute, and I can understand from the retail section, yes, it is a dispute. But for me, it's not about us. It's not about residential wanting more or wanting more benefit. It's really about fairness and that's all that this is about. At some point in time, a calculation was done that showed that the water usage was swayed towards retail. So that's what the trustees at that time did. And what I've been saying all the way along is that we either need to get a legal opinion that says what the trustees did back then is wrong, it's not allowed, or we need a new determination of what the current split is in a way that's agreed by everybody. Then if it's fair, it's fair. It's not but for, in my opinion anyway, for a component to simply say, well, you need to have all meters in every single apartment and whatever the case may be, otherwise you can't do it. We needed to have an opinion on that, which we now have.
We do. What is the opinion?
Well, I'm asking Oren.
Yeah.
Do you need to have meters in every single section for this kind of split that's been determined to be upheld and valid?
So I think let's take a step back. As I explained in the beginning when I did a quick overview, there's effectively three methods of recovery in terms of the Act. So the first method is a straightforward PQ recovery basis. So that is if you don't have meters installed, then the globular usage of the BC is shared amongst all members, regardless of whether or not they use the water on a PQ basis.
In PQ, yeah.
The second is if the body corporate passes an ordinary resolution to install meters to recover the costs on a usage basis. So that requires firstly an ordinary resolution, and then it also requires every section to have meters installed. And secondary to this is prepaid meters. That requires a special resolution. If you go the prepaid meter route, that requires a special resolution. Yeah. The third option, which is arguably the one that applies to the village, is recoveries in terms of a determination made in terms of section 11.2, which you have a determination, but it's not. It's just debatable whether utilities fall squarely within this determination. So in other words, whether if it relates to a specific component, they need to pay for it, or whether it falls in the other. That in terms of 26.10, the other expenses not referred to in the determination that's recovered on a PQ basis. So, sorry, Chris.
I didn't understand that third one.
So let me try and explain the third one. So the problem, okay, the third one is if there's a determination that modifies PQ, then the cost relating to utilities is not recovered on a PQ basis, but in accordance with the determination.
Okay, sorry.
Now you have a determination in terms of 26, Conduct Rule 26. The problem with the way that's been worded, though, is depending on which camp you're sitting in, retail or residential, you could find problems with the determination to argue that water, or at least I'm going to call it utilities, electricity and water, that utilities are not specifically included in the determination. So in other words, it's not in one of the categories that allow for it to be split between the two components, but in fact, it falls within Conduct Rule 26.10, which are expenses other than those referred to in the above determination. And that's where this dispute is going to, I think, end up going. Yeah.
Just according to basic law, if trustees are given this power to make a decision, and they make a decision, and it's claimed by the minority that it's unfair, is our next choice just to take the matter to court then?
So I think that's a good question. And if one looks at the wording of 26.9, it says that the trustees must apportion the expense in a manner that's equitable, right? So
yes,
one has to look at what is equitable in the circumstances. So if you have, I'm just going to use an extreme example. If you have a board, and I'm using it in the opposite as well, so that we're not knocking. If you have a board of 3 retail and 1 residential, which I know you don't, but let's say you do, and the retail guys decide we are going to pile on all the expenses onto residential, and because they're the trustees, the majority make the decision. That isn't an equitable decision, because clearly it's not equitable. They have to, as trustees, you need to be objective, and you have to carry out your fiduciary duties towards the body corporate, not just your caucus, but the entire body corporate. And one needs to hope that common sense will prevail when you're making this decision about equitability. But yes, to answer your question, Chris, too, if one component of the trustees, after the decision has been made, is unhappy that is not equitable, they would then need to take further legal action.
Okay, so that's the position now I feel that they're choosing not to default to the regulation that's outside the developers' rules, which is what I feel needs to happen. According to point 1 or 2, you gave 1, 2, and 3. I believe we have to go to 1 or 2, either install everybody meters or go to 1, which is all PQ.
I think that also, just to make myself clear, 1 or 2 aren't applicable. I can confirm that they're not applicable to the village, because you have a determination. 3 is the applicable methodology to the village. Now it's about determining or deciding where will that expense fall. So is it in the, you've got 3, in your determination, you have 3 categories. So the one is expenses incidental to a specific component, which is clearly incidental to that component. The other is where it isn't clear. The trustees make a call on an equitable basis. And the third is, if it doesn't fall into any of those 2 categories, then it's on a PQ basis.
Yeah.
So that's just to make it clear. The first
sorry to interrupt. So really, what I mean, from what my understanding is, it really depends on the measurement, how it was done, whether that's equitable or not, and whether we're prepared to do some other form of measurement which is equitable or not. That's really what it comes down to. Okay.
Well, look, and I'm going to argue for both sides. I'm first going to argue for the residential side, okay? And reading this rule, I will find a clause in this determination under 26, which makes it clear that, or at least it's arguable that the water usage, we can determine that the water usage or a certain percentage is incidental to the retail component, and therefore we recover it directly from them. And that'll be my argument. It's an incidental cost, and in terms of the rule, would split separately and done on that basis. Now, the problem with that argument is, without accurate meters, you can't determine what that percentage is, right? So even though you can have a rough idea that it's incidental to the retail, you can't give a rand value because you can't calculate it. So that would be my counter argument for the retail guys. Now, the retail components argument will be that the cost of water and electricity isn't mentioned anywhere throughout the determination. There's no specific reference to it. Those references in the rest of the determination are vague. So I will argue for them that it's then in fact a conduct rule 2610 expense. So in other words, an expense that's not referred to in the determination, and therefore it must be borne on a PQ basis. That would be the retail guy's argument.
Okay, cool.
So I think the most positive way to approach this is 2 ways. Is, I think, the best case scenario, and I don't know if this is practical in your scheme, but the best case scenario would be to just go ahead and install meters. Now, some buildings that isn't practical, especially the older ones. But if you can get that done, that solves this whole problem. Okay. The less costly option would be for your trustees to sit down and reach an equitable solution.
Yeah. I'm all for that. I mean, that's I don't think that as I mentioned at some point, the water consumption as time goes on is being reduced and reduced. We have a problem with our water well at the moment, so we currently are on municipal water, but generally speaking, it's getting less and less and less as that system improves. So it's really a matter of discussion between retail and residential to come up with an amicable thing. I think taking a polarized stance in it is where the problem has been all the time, where there was a determination, there was at some point a determination. That's I suppose what I'm really trying to get here is that at some point in time it was determined that retail uses more water than PQ, and so there was a thing, so there was a decision made on that. To now just revert, it would be, I feel it would be irresponsible of the retail trustees to just go, okay, well, the retail wants this, let's just give it to them. It needs to be discussed, which we can do it without your involvement in it. But that's kind of, it needs to be amicable.
Yeah. And look, the other option, if for some reason the trustees just can't get a meeting of the minds, is to look at finding an objective party to mediate those discussions, and for you to then enter into some mediation agreement before going to further legal action. It's rather stop
and to draw a line on it, because I think the energy that's been expelled on this matter over the years and over the years, if you calculate the time and effort that's gone into it, it's really not. It's worth it. It's obviously worth it for one, but I think, Christo, I think that you and I can discuss, and I think we can come to some form of agreement.
Yeah, I think we need to just be clear. You and I need to be clear exactly what is being discussed here. And I think we need to unpack more details around it, because there's. Like the retail, which is 10% of the retails in an apartment block, which has got no meters, it doesn't use water, so they don't have water installed like the apartments have for kitchen and more, that sort of thing. So there's a clearly a hiatus of the thought around it, which isn't even covered by it.
Yeah. Okay. Cool. All right. I mean, what is our total water expenditure? I think in the last budget, I think it was worked out to about 40,000 Rand a year. Am I right?
It's gone. Yeah, it's gone down, but it's only 10% of what it used to be, almost.
Oh, okay.
On that basis, it definitely wouldn't make sense to go legal on this.
No. This is what my point is, and never mind the legal expenditure. It's the time and effort that's been going into it year after year after year. So. Yeah. Retail and residential need to sit down, be reasonable, and go, okay, let's do it on this basis. And got to do it on a basis that it's then made that's what the agreement is, and it's amicable. Unfortunately, and I say this without prejudice to anybody else, some of our trustees are sticklers, and getting it by them on a unanimous basis is going to be a nightmare. So it really needs to come with strong agreement between Christo and I, proposing it to the rest of the trustees and then taking it from there. I think that's the way to go.
Yeah. If I can just also mention, the 40,000 is not a lot, but when you're talking about a minority, it's now 13, just over 13%, because we converted certain retail into residential. So it's now about just over 13%. To pay 13% to pay 40%, then it's arguable,
It's unfair. It's unfair if the water usage isn't in that component. I completely agree.
Yeah. So anyway, then there are the other matters like the meeting, the basic, the other ones, the count auditing, doing the books and that. We've spent all the time talking about the water at the moment. Is that more straightforward or what?
So this should be more straightforward, and especially given that in terms of your determination, you have to operate separate expense accounts. Now, what that means in practice, it's debatable, but one would assume that you would have to have a control account for each component. And then to audit your respective control accounts should be for the cost of that component. So if you're combining that into one set of financials, I think that's what you said is currently happening, but there are the separate control accounts under the guise of one financial statement.
Yes.
So depending on how many transactions each component has, that could possibly give you a guide on what the cost split should be. So if your auditors are spending 80% of the time on residential expenses on the control account of the residential, then that makes sense that it's an 80% split. But I mean, if we're splitting hairs of a 2,000 Rand bill,
that's not worth it. Yeah,
it's not worth it. To me, it makes sense that it's effectively an audit of both of your control accounts. So it's a split cost. So it's 50-50. So the way it's currently being split makes sense to me.
And if the retail goes to 5%, 5% must always pay 50%. See, that's where it goes. Where the small amount is a small entity compared to a big amount, and then they have to pay 50%. It doesn't make sense to me. So I hear what you're saying, but it doesn't make sense at all.
But I think that the response to that would be that PQ in respect of auditing and accounting fees is definitely not applicable in that scenario, because you have a clause in your determination which says expenses of a service provided to the commercial or retail component shall be borne respectively. Now, this is a service that's being provided, and there's therefore PQ is not applicable in that scenario. So
okay.
Yeah, where it's arguable that water doesn't fit in it, because is water a facility, amenity, or a service? I don't know, which is why I say it's grey.
So we have to go to the service provider and ask the service provider, like you just said, the amount of transactions and that sort of thing, or
that's one way to determine. Correct. Is remember, it's expenses of or incidental to the service. So you would, if you're wanting to drill down into the amount of time used by the auditor, you should ask them, how much time did you spend on auditing the residential control account, and how much time did you spend auditing the retail control account, and then split it on that basis.
Okay. Meeting expenditures, I think are so minimal. I would just, at the risk of speaking for the whole of the residential side, I would just suggest making that PQ. It's not even worth worrying about it. I don't know if you agree, Christo.
Yeah, I mean yeah, absolutely.
Yeah.
See, that's a type of decision that can be made on equitability then. Is that you decide that you deem it to be equitable to do it on a PQ basis, and that's the determination that you make.
Yeah, I mean, meetings are about the body corporate as a whole, which represents X amount. You get benefit of a meeting in PQ. That's how I would determine why the cost should be split that way.
Which is fine.
Okay.
That makes sense.
Yeah. Okay. And then obviously sewerage would be linked to water, etc., etc.
Yeah.
Okay.
Sewerage is calculated.
All right. Christo, I think Christo and I we can obviously have a separate meeting and discussion, but there was one other thing that I think Christo wanted to, if we have a little bit of time left, just to use it up.
Yes.
Was with regards, sorry, you go, Christo.
No, I think we're talking about the same thing, Adrian. It's about you mentioned the first page. Sorry, I've just forgotten your name now. And
Oren,
that's right. Oren, you mentioned the first page, which talks to the residential and the retail component, which must have a minimum of 2 trustees. And the question has come up every now and again, not often, but it comes up. If we have to vote over things we have in common, then the residential and the retail trustees, they vote. Now, the basic rule we understand is a trustee may not have more than 2 votes. You can only have 1 vote unless it's the chairman casting a vote. But yet, if the residential trustees and the retail trustees have 2 people who are represented on both. Oh, sorry, I have a person who represented on both, like myself, for example. So now I have to apply my vote according to some determination that I can only have 1 vote. I must either vote for the residential or I must vote for the retail. So our question is, can the trustees of the residential and the trustees of the retail cast their votes, irrespective of what their names are, and apply the votes, even if it's the same person that's in the residential and the same person that's in the retail? Or do they have to appoint someone else so that they can get a vote applied without excluding?
Yeah.
You understand what I'm getting at?
Yeah. Can I explain from my side? Maybe it'll make it clearer.
Absolutely.
So in my understanding, you can be a trustee of both residential and retail. In matters that are determined purely for the retail component, you vote, only the retail trustees vote in that. For matters that relate to the residential component, only residential trustees vote to that. For matters that relate to the body corporate as a whole, it's done on a 1 person, 1 vote basis. That's how I would. I think that's what we're trying to get to. Is that true, or does a person that's a trustee of the retail side and the residential side have 2 votes? I think that's in a nutshell what it is.
Okay, no. So let's assume that the 3 of us are trustees. Christo owns retail and residential, so he's a retail.
Which is true.
Okay, which is true. And Adrian, you residential, and I'm residential. So when we're voting on a residential related issue, the 3 of us cast our votes, because Christo will put his residential hat on. When we vote in respect of a retail issue, Christo will put his retail hat on and only he votes. When we vote in respect of a common or a general issue, the 3 of us have the 3 votes. So there will only be 3 votes cast, and not 4.
Not a 4th one. Yeah. Okay, that's what I'm.
So in other words, if we wanted to, if we regarded that as being unfair, then we would have to have someone else appointed. We'd get. I'm saying it's really to get the effect of everybody representative of their section, applying their minds relative to who they're representing, then it will need to be a different person, because then you.
It will need to be it'll need to be a separate trustee that's nominated and seconded and becomes a trustee.
Yeah. So one would just have to go to that trouble to get around the loophole that you can only have 1.
Yeah.
Because the rules don't talk to residential and retail in a way that makes it clear, in my mind anyway.
Correct. I mean, your rules, like I said, are drafted like as if it's a marketing material brochure. It doesn't give you enough guidance.
Well, I don't think you can even do the rules that countermand the Sectional Title Act. You can't say that. You can't change that, can you?
Well, the issue is that you can't have conduct rules which are irreconcilable with the prescribed management rules.
Yeah.
Arguably, your rules relating to trustees are irreconcilable with the rule, because trustees and their office is dealt with in terms of the management rules, the prescribed management rules. So
right.
you're tweaking those roles in your conduct rules, which are arguably irreconcilable. And this should be housed in your management rules, this issue about the trustees. So that's just a whole different kit, a whole different Pandora's box that you can possibly open.
Yeah.
Um,
Or yeah, does the advisory do that kind of thing? Consultation and redrafting of rules?
Yes, yeah, we offer two types of services in that regard. Either we redraft the rules from scratch for you, given in light of the instructions you give us, or we review rules as you prepare and suggest any amendments. So the one will have a higher cost than the other, though. Drafting obviously will have a higher cost than a review.
Yeah. Okay. Great.
Okay.
Anything else, Christo, or you?
No, I can't think of anything else right now. I think we got some good value here.
I think the fact that you haven't spent thousands on litigation over the years is I think testament to the fact that you are trying to reach reasonable compromises, because this is easy. It's very easy under these rules to get litigious on very small issues. So just kudos to both of you on that.
Well, yeah, it's. I mean, as we say, the amounts involved are small compared to, to get the emotions in the way of spending money are necessary, but it's just that it's going on for so long now that
it's actually it's not only the money, it's the amount of effort and time that's gone into it without you can't put a value to that. So I think, Christo, you and I must schedule a time to meet, have a chat about it, and so we're taking up I think more of Oren's time than we were due to already, and then we can come to something that's reasonable, and we can promote that to other trustees and get that all finalized.
Yeah, fantastic. Okay. All right, gents. Well, as usual, good seeing you again, and
thanks, Oren.
Give us a shout if there's anything else.
It's been extremely valuable, all three of our sessions. So
thank you.
Fantastic. All right, have a good one. Cheers.
Okay.
Bye.